Montek, do you think events like DAW are going to basically create an opportunity for India to become a preferred seat of arbitration?
I think the short answer is 100%. I think the first step in that process is to both create awareness and education, and second is to invite best practices from the world. And I think DAW is doing that very well in bringing together international practitioners, domestic practitioners, the judiciary is involved in this, and that's for me the very first step if you want to create a seat for arbitration in India.
You have attended many arbitral weeks. How do you think that DAW is different? What are we doing different in order to bring that kind of...
I think, so I've been associated with DAW from the very first one. I think its ability to attract the different ecosystems that exist within the legal field, by which I mean the client's perspective, the judiciary, the government, the actual practitioners, that is quite unique, at least in my view, to DAW. And that's something it does consistently quite well. And that's quite different, like I said, from international events that we see, which are often mostly practitioners based, for example. You might get some involvement from the government, but not the way DAW has been able to do.
What is the biggest misconception lawyers have in engaging with financial experts?
That they don't need us. That's the biggest misconception. I think it's, I wouldn't say misconception, I think it's lack of information and awareness.
What do you want to say to them?
I think nothing actually in that sense, in the sense that I don't want to promote myself. I think the point here is that some matters, not all of the matters, require deep experts on subject matters and technical issues. And I think in those matters where I genuinely believe experts can bring value, right? When you're thinking about difficult damages claims, when you think about difficult valuation questions, when you're thinking about loss of profit claims and contract breaches, it often requires evidence that's not available to the tribunal. And I think that's one place where experts can add value to the process, right? So I think at the very outset, clients and counsel need to understand their case, and cases that involve damages questions or valuation questions where the expertise does not exist within the team, that's where we can add value, right? I think that information and alignment is quite important, because without which, obviously, people like us will not get engaged, right? And I think today what we're also seeing is tribunals, both domestic and international, are increasingly looking for reasoned damages calculations that are based on evidence that are robust, and that is then features into the awards that you see that are coming out from these tribunals. And to get to that stage, for parties to be successful in that pursuit of damages, I believe people like us can add value.
And what do you think, what kind of reforms are required to make the India as an arbitration hub?
I think that's a question that perhaps goes partly also beyond my scope of work and expertise. But I think what I see is perhaps what I answered in the first question, right? You need to first have the support from all the ecosystems that are part of the system, right? I think that's the first and foremost, I think, requirement. I don't genuinely believe, and like I said, I'm now addressing issues which are perhaps beyond my expertise, but I don't think there's any prohibition or limitation from a legal aspect. Our laws are quite strong. We've been very good about reforming our act when it's needed. We're very, I believe, responding.
Somehow 2019 amendment bill didn't come well.
I think so, but I think the question really here is, you don't see reinvention of arbitration acts around the world, right? You need to be aligned with best practices. The larger issue is the actual practice of that law, which I think requires a bit more concerted effort from all of us, and not misusing or using the loopholes that might exist. And I think the other thing I must confess, which I think will go a long way in promoting arbitration, is having awards on costs. So that's one thing India doesn't do as well, which is that it doesn't award costs against the losing party, which therefore then promotes frivolous litigation and arbitration work. I think if we are much better about awarding costs, that would be a natural sort of support system. That will create a natural support system for arbitration, because people will not challenge awards as often, and they will limit frivolous litigation to the minimum. And that's, I think, the biggest difference between us and the UK and Singapore, where courts are not shy from awarding costs, and very large costs, right? And I think that creates the right ecosystem. So I think once you get that finality of an award or a judgment in India, you'll absolutely see people use India as an arbitration hub, or India becoming a much bigger player in arbitration globally. But I think that's my view, that's one of the most practical steps that we can actually take today, because the rules and the laws exist for us to do that. It's just that tribunals and judiciary need to exercise that power.
Perfect. Thank you so much, Montek, for giving your time.
Thank you.
Thanks.
Thanks a lot.
Thanks.